In the meantime, the High Court will mid-February rule on a petition challenging the National Transport and Safety Authority regulations restricting graffiti, artistic designs and customized features on public service vehicles, with the petitioner arguing that the rules unfairly target the popular Nganya matatu culture.
The case was heard on January 21st before Justice Bahati Mamoye at the Milimani Law Court, where petitioner Michael Makubo William, through lawyer Outa Malela, told the court that the NTSA regulations were introduced without adequate public participation and were not properly subjected to parliamentary scrutiny as required by law.
The first and second respondents have attached a notice published 10 years after the regulations. Now they are calling people to submit views for intended amendments. That is what NTSA has submitted before you.
He added that Nganya culture is a form of artistic and cultural expression protected under the Constitution and supports livelihood in both transport and creative industries.
The promoters of those draft regulations never gave sufficient information to the general public in Kiswahili, which is the national language of our republic.
The petitioners claim that NTSA failed to provide concrete evidence linking decorations to road safety risk.
That be as it may, if peradventure that the petitioners are right to submit that the PSV regulations are illegal, which is not true. Even if it was so, we refer to the court to the presumption of constitutionality of legal instruments.
The state opposed the petition, maintaining that the rules were lawfully enacted, reviewed by the parliament, and only sought to regulate, not ban vehicles' decorations in the interest of public safety.
We speak, kuna hata watu wetu wengine wamekuja hapa late kwa sababu wameshikwa. Nganya culture yani matatu ni ile yenye polisi akiboeka na kupiga mkono na kushika. Moving forward, hizi ni vitu zenye sisi watu taki. Na tuache hypocrisy. When tourists wanakuja, ndio hata government officials, they want to embrace the Nganya culture.
And the Kenyan non-governmental organization Sheria Mtani, through Council Shadrack Omboi, has moved to the Environment and Land Court, seeking to compel the government to implement 12.3 billion Kenya shillings land settlement loan waiver approved by the cabinet in November 2025.
The resolution made by the cabinet that moving forward, those interests will be waived. The loans that had accrued will be subsidized. However, since the passing of that resolution, nothing has been done.
The petition filed in a certificate of urgency accused the senior government officials of failing to operationalize the waiver on accrued interest and penalties affecting settlers in 520 schemes across 26 counties, delaying the issuance of title deed and worsening financial hardships for low-income beneficiaries.
We are demanding that the government now, because already 3 months are over, extends the duration from the remaining 9 months to at least 2 years for this to be done. And lastly, sensitization.
The court is yet to issue its directive.
Under Section 26A.
Finally, a Nairobi magistrate court has fined a Congolese national 40,000 Kenya shillings after he pleaded guilty to charges of unlawfully being present in Kenya, ordering that he be deported upon payment or completion of the sentence.
Service of default sentence. The convict will be repatriated to his country of nationality as provided under Section 26A of the Penal Code.
Much obliged.
If you are not satisfied with the sentence, you have the right to prefer an appeal within 40 days.
Letua Debra for Prime Edition.